Alex here with a perspectives video on sentencing, far and away the most popular subject brought to our attention by our viewers. A camera team is in place at District Judge Joe Hardy Jr.'s chambers. I'm sure many who watch this video will wonder why specific questions weren't asked with regards to some of our recent trial coverage. So I'd like to just point out that Judicial Canon 2.10 forbids the judiciary from commenting publicly on pending and impending litigation. All that being said, let's get straight into it. We are here with the Honorable Joe Hardy Jr., Eighth Judicial District Court. Why don't you let us know a little bit about you and your campaign to retain your seat on the bench in Department 15?
Sure. So I was born in Reno, raised in Boulder City. I'm actually a third generation Nevadan, so grew up in Boulder City. I've been a judge now for almost 5 years. I first ran for judicial office in 2014. I tell people I was the best loser because I came the closest out of the races. But right after that, I was appointed to the bench by then Governor Brian Sandoval. There were, I believe it was about 25, 26 applicants for the position, and I was one of the three finalists and then appointed by Governor Sandoval. I had to run for retention in 2016. Which I won, thankfully, pretty handily, about a 60-40 split. And I've been on the bench now almost 5 years, like I said. I am now up for a re-election campaign. I have two opponents, so I'll be on the June primary. I love my job. It literally is my dream job. I externed for Judge George here in federal court while I was in law school, and it was there that the seed was planted to think the seed in my mind anyway, to think, oh, maybe one day in the then far off future, I would like to be a judge. So love my job and am happy to serve the public here in Clark County.
Awesome. And I just want to remind the viewers that we have all of the election data on our website, including the dates and times of both the primary and general elections. So the theme for this perspectives video is sentencing. One of the most common questions we get from the viewers has to do with what kind of thought process goes through a judge's mind on deciding which charges run concurrent versus consecutive.
Yeah, so generally on the consecutive versus concurrent, I think that the general, I don't know if you could even call it a rule, but the general rule, if that's about the best word I can think of it, is to generally run concurrent to each other, but it really depends on the nature of the charges, the nature of the crimes, and a lot. Sentencing is actually one of the judicial tasks, if you will, where the sentencing judge, like myself, has a lot of discretion. So overall, sentencing, you're looking at, as a judge, you're looking at prior history. That includes family history of the defendant, substance abuse history, criminal history, the nature of the crimes themselves. So a lot of that goes into it. We are bound by, they're not guidelines, but bound in the NRS, there are minimum, maximum time limits on those, and so it's within that minimum and maximum that the judge has pretty wide discretion. That also goes into discretion, also goes into, whether to serve in prison versus probation. That's another issue that always comes up.
Okay. Another question we have has to do with sentencing ranges. When a judge sentences someone to, let's say, 3 to 7 years, one of the most common questions we get from the viewers is, how is it actually decided precisely what time will be served?
Yeah. So, like I said, the range is in the statutes themselves.
Mm-hmm.
So, if it's a minimum, let's say a lot of them are minimum 12 months, maximum 4 years. So, a year to 4 years. Within that year to 4 years, the judge has almost unfettered discretion, although the minimum cannot exceed 40% of the maximum. So if you're looking at 12 to 48, and let's say you wanted to give the maximum in that range, it would have to be 19 months to 48 months. And when you're determining what to do in that range, a lot of times in sentencing, it's a result of a plea deal, and the state and the defendant often will have agreed on, what range they would like the judge to give. Although even with that, the judge still has discretion to depart downward or upward from that. And so a lot of those factors that I mentioned earlier go into that determination in terms of where in that range to offer. In terms of the time that is actually served after that sentence, there's what I would characterize as a plethora of statutory rules in terms of good time credits, work time credits, all sorts of things that can affect the actual time that is eventually served.
Okay, that's so much detail. The viewers for this channel are very technical, and they love that kind of detail, so that's appreciated. We just have three more.
Sure.
We get some questions on the PSI, or pre-sentencing investigation report. How does this report fit into the decision-making process? And I've also seen some appellants complaining when the recommendations of parole and probation are rejected. And can you give us some insight into why that might occur?
Yeah, sure. Those are excellent questions, because if you're not familiar with the process, then it's hard to understand how it works. So to back up a little, and maybe your viewers already know this based on that question, but in case they don't, we get a PSI pre-sentence investigation report before we sentence. So say somebody went to trial and they were found guilty, or they entered into a plea. The sentencing doesn't occur until, depending on a bunch of different things, a month or two after that. And during that time, Department of Parole and Probation prepares that report. And that report contains a lot of those things that I mentioned earlier: family background, education, criminal history, and Parole and Probation have basically a type of guideline, a formula that they assign various weights to, and then they come up with a recommendation. Now, again, even with that recommendation, the judge still has very, very wide discretion in terms of, you can accept that, you can depart upward or downward, so long as it's within, the statutory requirements. A lot of judges, including myself, if the state and the defense have, quote unquote, worked out some type of deal, it takes a lot of good reason to depart from that if they've done that, because as a judge, we're not, especially if they plead, we're not familiar with a lot of the background and issues that went into that negotiation. So we rely on both the state and the defense attorney to kind of come up with an agreed upon type of recommendation from them. Another thing we account for too is the victims. And so the victims, they get notice, they do get notice, the sentencing's coming up, and they have the opportunity to come in and speak in front of us. So we take that into account as well.
I lumped two together, so we just have one more. From what from what I've seen, it seems a pretty standard practice for a defendant to exercise his right to remain silent during trial, but speak during sentencing. How often does it occur that a defendant declines to speak during sentencing, and what kind of impression does that have on a judge?
Oh, sure. Yeah, your viewers ask great
They
questions.
do.
Um, yeah. So, yeah, typically during a trial, the defendant will exercise his or her right to remain silent for all sorts of reasons. Sometimes I've had, in my um, year and a half plus, I've had a couple trials where the defendant did testify. Um, but at sentencing, as your viewers obviously know from that question, they can speak. And I'd say if I was trying to give out rough percentages, most of the time the defendant will have something to say at sentencing, although usually if so, it's not a lot. And they keep it pretty minimal, if you will. They typically will apologize, say they're sorry, those types of things. Um, the effect of the defendant speaking or not at sentencing, um, for me as the judge, I don't think it really plays much of a role. It can a little, although like I said, most of them will apologize, um, and
Mhm.
uh, it's rare that I go into sentencing generally having an idea of what I expect I'll do um, before they even come in. So it's rare that I would change my mind or be affected by anything that's said by the defendant at sentencing.
Thank you so much for coming on today. The viewers will definitely appreciate it, and best of luck to you.
Thank you so much, Alex. Appreciate it.